Right, thanks everyone for joining us this morning. It's the next instalment of our Everything You Wanted to Know series. Today we're on to discrimination. We've covered quite a few of the key things that a lot of our clients are dealing with on a day-to-day basis, and this is obviously another huge area that's happening that affects the kind of work we do here every day when we're employing people. So obviously the majority of employers and the majority of people on this call, the businesses you work for, will strive to promote equality and diversity in your organisations. But it can often be quite unclear, or you can be quite uncertain about the precise legislation on discrimination. It is notoriously complicated. So today we wanted to answer some commonly asked questions to help you understand what your obligations are, making sure you meet them and achieve your aims of being an equal opportunities employer, particularly with reference to the Equality Act 2010, which is where most of the discrimination legislation is contained. Now, we'll be going through a few of these key questions today, but as we usually do, we like to run these as quite interactive sessions. So if anything we say you've got questions about, you're unsure, you've got any examples you want to bring into the discussion and chat through, as long as you're happy to do that, then please jump in and join the conversation. It's always works much better when we've got a bit of a discussion and debate going on. So without further ado, the first question that people often ask, is not necessarily as clear-cut as people might think, is what characteristics are protected by the Equality Act? Most of them people will be able to name off the top of their heads, but there's one or two they maybe might forget or not realise are covered. So firstly, defining what a protected characteristic is, really it's an attribute that relates to an individual that's protected by the legislation. And these are the characteristics upon which employees can potentially mount a claim, or at least a complaint based on discrimination. Now, there is a list of protected characteristics in the Equality Act. I'm just going to go through those now. As I say, some of them will be ones you're very familiar with, others maybe less so, or it's easy to forget some of them. So we've got age, we've got disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, which includes colour, nationality, ethnic origins, or national origins, and that's the language used in the legislation, religion or belief, or even a lack thereof, sex or sexual orientation. Now, as I said earlier, it's not always clear cut what those protected characteristics are, even when we know the list. And as a result of that, we're seeing more and more these days, we're seeing more and more cases in relation to characteristics which may not be specifically recognised in the list I've just mentioned, but which may in some ways be related to a recognised characteristic. So by way of example, we've seen recently over the last couple of months, you may have all seen this, we did a blog on this. An employment tribunal recently found that being bald was related to the protected characteristic of sex. That was on the basis that mostly it's men that suffer from that condition, and indeed in the decision, the judge even made a comment about his own baldness. But because it was something that affects mainly men, it therefore attracted the protection of the Equality Act in relation to the protected characteristic of sex. Obviously, that caused a lot of debate, a lot of misreporting, should I say, in the media about exactly what that case meant. It wasn't creating a new ground, a new protected characteristic, but it was fitting certain other characteristics within the framework of the protected characteristics we already know so well. And similarly, characteristics such as obesity, which can be linked to or can cause other medical conditions which amount to a disability, or for example, certain hair colours, things like that. Like you've seen cases being argued, or at least complaints made on from people, for example, with ginger hair. They may say that that's linked to their racial or national identity, and that can in theory be protected as well under that protected characteristic. So it can go much wider than the list immediately suggests. Now, it's also worth noting that some of the wording in the legislation around gender reassignment is now at least 12 years old. So the Equality Act 2010, 12 years on from that, people's understanding, the kind of discussions and debates in society have moved much further on, in particular in relation to what was referred at the time to gender reassignment. It's clearly an area that's grown in prominence more recently, and it's led to a number of cases in that time which seek to determine exactly who may qualify for protection under this characteristic. So, for example, the wording of the legislation, it strictly envisages someone who's proposing to, or has, or is currently undergoing a process to reassign their gender from one binary gender to another. So effectively, someone who was assigned one gender at birth, reassigning to another binary gender. Now, clearly that opens a debate about binary and non-binary genders, which were not necessarily envisaged when the legislation was first drafted, and that's where these cases come in, to basically clarify the scope, to say that yes, it can include people who identify as gender fluid or non-binary, or to clarify, for example, that the requirement to be undergoing a process doesn't necessarily mean a medical procedure or a process or treatment. It can be a personal process identifying with a different gender. So there are certain areas of that that's left unexplored still, but it seems that the way the cases are being decided is making sure that that protection is as wide as it can legitimately be. So that's just an example to say that, yeah, we've got this list of protected characteristics, but it's not always as clear cut as it might seem. Now, as well as the protected characteristics, we also have different forms of discrimination. Not all discrimination is the same. Julie's just going to take us through the different forms or the different types of discrimination on the grounds of those characteristics.
Thanks, Gareth. The other thing before moving on to that I was going to mention is that we actually had a case in relation to a client in the hospitality sector, and they had somebody raise a claim based on race, and it incorporated their nationality, and the person who worked with lots of international colleagues said that he had been discriminated against on the grounds of his Britishness, because comments he had made had been misinterpreted in a culture where there was lots of people from all over the world. So ultimately, thankfully, his claim didn't really go the distance, which was good for our client. But just to let you know that race includes colour, nationality, ethnic origins, national origins, and I think some people have also tried to mount, I think someone tried to mount a claim based on his Englishness in Scotland, because I think that's the last form of tolerated racism in Scotland. You can still be mean to English people, and obviously that isn't acceptable, and they rightly use the legislation. So as Gareth said, really, really wide, and it can encounter and encompass all sorts of situations that you wouldn't necessarily think at first instance would be covered. So moving on to what form discrimination can take, there are obviously many different types of discrimination based on the individual's protected characteristics, and I'm just going to list a few of them. So the first one, this is the one we're probably most familiar with, which is direct discrimination, which is an employer treating someone less favourably than they treat or would treat others because of a protected characteristic. So for instance, not employing someone because they're pregnant, that's direct discrimination. We also have indirect discrimination. So that's where an employer appears to treat all workers the same, but the treatment affects one group of workers adversely compared to another. So the example I often think of is that years ago, there was a height requirement to work in the police, which obviously adversely affected women because we tend to be shorter. And so that can be potentially indirect discrimination. Well, it was indirect discrimination. You can also have discrimination arising from disability. So obviously treating a disabled person unfavourably because of something arising in consequence of that disabled person's disability. For instance, not letting them go on a trip abroad that other work colleagues are going on because it might be awkward or more expensive to accommodate their travel requirements, for instance, something like that. Failure to make reasonable adjustments for a disabled person, that's probably something you're all quite familiar with, which the concept, failing to take steps to adjust a workplace practice or physical working environment where a disabled person, where it would help a disabled person remove the advantage in comparison with people who are not disabled. Specific discrimination in relation to pregnancy and maternity, treating someone who's pregnant or on maternity leave unfavourably. The maternity leave one, I think, is particularly important. For instance, sometimes, if you're running a redundancy exercise and you've warned all the staff, you quite often will call a meeting, and you've got to remember to inform or invite the individuals on maternity leave. Harassment. This is subjecting individuals to conduct that is, and it's a very wordy description, but it's unwanted conduct, which is the purpose or effect of violating the victim's dignity or creating an environment that's intimidating, hostile, degrading, humiliating, or offensive. Now, that wording obviously is to try and prevent individuals mounting claims based on trivial conduct. It has to be quite serious conduct that makes the person feel uncomfortable. And then finally, there's victimization. Again, quite often you'll see claimants saying they've been victimized because, and what they mean is they've been treated badly. That's not what victimization is. Victimization is subjecting an individual to a detriment because they've complained about discrimination. So for instance, if someone has complained about being discriminated against and then they are overlooked for promotion or some other way treated badly because they were making a fuss effectively, that's what victimization is. So we're going to focus on explaining the key principles in relation to the biggies, really, which is direct discrimination and indirect. But the key distinction is that an employer cannot objectively justify direct discrimination. There is no excuse, really. Whereas indirect discrimination, there is sometimes an argument to say it's there's a good reason for it effectively, and we'll cover that in more detail later. So I'm going to pass you back to Gareth to discuss in more detail direct discrimination.
Thanks, Julie. Yeah, so as you can see, there's quite a lot of different types of discrimination, and we're planning to focus today on direct and indirect. The third biggie, as Julie's mentioned, and probably would be harassment after that, but we really could do a separate discussion on that alone, and that's really where, and I'll come on to this concept a bit later in today's session, around having liability for your employees' actions, and where you see a lot of interaction between employees, things being said, management decisions and things like that are perhaps the type of things that come across your desk where you're trying to work out, well, okay, something's happened between them, are we liable? How's it happened? Does it constitute harassment, or is it just a falling out? That could be definitely a separate discussion all of itself. So we've left that out of today, and we're focusing instead on direct discrimination and indirect. Now, turning first to direct discrimination, it's worth just bearing in mind before we delve into this that this is the type of discrimination that you might consider to be the most obvious type of discrimination. So a business or an employer doing something detrimental, and I'll come to what the actual definition is, but just in layman's terms, against an employee, and they're doing it directly because of one of those characteristics we've just mentioned. Now, for that reason, it can be slightly rarer to get this type of discrimination, and when it happens, it can feel a lot more blatant, but nevertheless, it clearly does still happen, and we do still have to make sure that we avoid this type of thing. But actually, much more common is going to be these things that employers don't necessarily realise is or could amount to discrimination, but inadvertently ends up being the case, or it doesn't necessarily strike the employer as obvious that that's a discriminatory decision to make. But with direct discrimination, it will usually be a bit more clear cut. Not always, but usually in my experience it will be. So just moving then on to how we actually look and define direct discrimination. The actual definition of it is where a person treats another person less favourably than they would. So when I say a person, it's an employer. So an employer treats one of their employees less favourably than they have treated or would treat others, and they do so because of a protected characteristic. Now, because of the way that's defined, there's a need there for a comparison, for a comparator. So it's necessary for an employee who complains of direct discrimination to point to the person that they say was treated, that they were treated less favourably than. Now, that person can be a real comparator. I've been treated differently from Julie because I'm English and she's Scottish. But there could be a scenario where there isn't an actual real life comparator, and therefore the legislation allows you to compare yourself to a hypothetical comparator if you're the employee. So I could say there's not a specific person, but I've been treated differently than my employer would treat a Scottish person because I'm English. Clearly, when those kind of hypothetical arguments are being made, then it has to be quite clearly defined as to who that would or might be. But a lot of cases are brought on the basis of hypothetical comparators, and often you can have quite tricky areas, particularly with things like sex discrimination claims. You might think that you would obviously compare yourself to someone of the other sex, or a different sex, should I say, whereas it may not always be as clear cut as that, because you may not be someone that you can directly point to, because it's a hypothetical to say, well, as a person of a particular sex, I'm doing this job, and everyone else that's doing it is also of my sex, so I can't point to someone in the same role that's not been treated less favourably, but I can identify a hypothetical person that I believe would be treated less favourably. So it can become a complicated area, but it's just to say that, yeah, most of the time it'll be easier to point to someone to have been treated less favourably than them, but occasionally there may be these hypothetical comparators that are used by employees that are complaining of discrimination. Now, it's also worth bearing in mind that merely treating a worker unreasonably or unfavourably will not in itself amount to direct discrimination. It has to be about this comparison, being treated less favourably than someone real or hypothetical, not just that my employer treats people unfavourably for direct discrimination. Now, in a strange sort of way, if it could be shown that an employer would have treated or does treat all workers similarly badly, regardless of their protected characteristics, then it wouldn't be a discrimination case. It may lead to other types of cases. It may lead to complaints around unfair dismissal and constructive dismissal, but in terms of a direct discrimination case, merely unfavourable treatment is not the basis of a direct discrimination claim. Clearly, it'll often be difficult for an employer to explain blatantly unreasonable treatment, and it'll be hard for an employer, or it would be, you wouldn't really envy an employer who tries to say, well, my defence that I'm mounting is that I'm just horrible to everyone. You know, it's not necessarily putting them in a good position, so it might be more easily inferred that discrimination has played a part within that in the absence of an adequate explanation for the unreasonable treatment, but it is still worth making that comparison. And similarly, different treatment is not necessarily the same as less favourable treatment. It must be shown that objectively the treatment of the employee who's complaining was worse than that of their comparator. Different treatment that's no worse isn't in itself then a basis for a direct discrimination claim. Now, as well as the requirement for less favourable treatment, is also required, as we saw from the definition, that less favourable treatment was caused because of a protected characteristic, whichever that characteristic is. So you have to show that it happened because of it, and that's the next part of meeting that definition if you're an employee bringing a claim. For example, an employee may allege that their employer exploits them because they're vulnerable as a result of their poor economic position, because of poor English or low levels of skills, their immigration status, homelessness, mental disability, etc. Now, it does not necessarily mean that the employer has committed discrimination in those contexts if those reasons do not necessarily fit within the realms of protected characteristics. Now, as another example, there was a case where a non-executive director of an NHS trust, who also sat as a lay magistrate, opposed same-sex adoption and widely publicised the views in media interviews. Now, the Employment Appeal Tribunal in that case upheld the finding of an employment tribunal that the termination of that person's appointment was not because of their religious belief, but because their conduct, in that they'd accepted, basically they'd gone on and accepted appointments in the media to make these comments without telling the employer. You know, it's not just about holding those views, they'd gone off and actively sought to disseminate them. Dismissing the employee for those reasons was not deemed to be because of his religious belief, even though he truly believed that that was the case. So there can be these little grey areas where, and this is what obviously cases are all about, where there's an argument about, well, was it because of the characteristic or for something else? Occasionally where that's linked or in some way connected, it may not necessarily be enough to say it's because of. And just one final thing to mention around direct discrimination is the concept of associative direct discrimination. Now, currently discrimination because of an association with a person of a protected characteristic is only expressly prohibited in relation to direct discrimination and harassment. So not recruiting someone or harassing them because, for example, they have a disabled child or family member can be the basis of a direct discrimination claim for that person. So they may not themselves have the protected characteristic in question, but they've been treated less favourably because of that characteristic that belongs to someone else. They can still potentially bring a claim in relation to direct discrimination. So not always clear cut that something meets the definition of direct discrimination, but most of the time it should be relatively easy to at least consider whether that might be the case. And it's for that reason that issues such as indirect discrimination may become more relevant because it may not be as overt as direct discrimination. And Julie is now going to take us through some of the details around how an indirect discrimination claim could be formed, definitions around that, etc.
Thanks, Gareth. Yep, so as I mentioned earlier, essentially indirect discrimination is where you have apparently neutral treatment, but it has discriminatory consequences. So I'll take you through the definition. It's a bit dry, but stick with me and we'll try and kind of break it down. So essentially, it happens where A, who's normally the employer, applies what's called a provision, criterion, or practice to B, who's the person who's going to sue you for discrimination, essentially. And and we'll call that a PCP. So it means a provision, criterion, or practice, and that they apply that PCP to everyone. They apply it to everyone, so not everyone will possess that protected characteristic. So if we take our police force height requirement, all police and personnel were required to be a particular height. It wasn't applied just for men or just for women, but by applying that requirement, it disproportionately impacted a class of individuals who had a protected characteristic. So it disproportionately impacted women. And then you also have to be in that class. Obviously, you have to be a woman to then raise the claim. And the final point is that the employer can't justify the treatment as a proportionate means of achieving a legitimate aim. So back in the day, I think the argument by the police was that in physical situations, you needed bigger, taller people to potentially deal with it. But as time has gone on, training has changed, different pieces of equipment can be used by the police officers, then they no longer can really justify that requirement, which is why it has now been done away with. In fact, I remember talking to a police officer, a woman, and she said that when she started in the 80s, she was still required to wear the handbag. I don't know if you remember from the bill and things, like they had a handbag with their uniform. So, you know, times have hugely changed, and now that can't be, that requirement can't be justified, and that's a really good example of indirect discrimination. So just to look a little bit more closely as an employer about what a PCP, a provision, criterion or practice actually is. So direct discrimination requires, as Gareth mentioned, a causal link between the less favourable treatment and the protected characteristic, but indirect discrimination doesn't. Instead, it requires a causal link between the PCP by the employer and the disadvantage to the group and then to the individual claimant. So it's obviously really important to understand what constitutes a PCP. So essentially, identifying the PCP, there's no definition, of course, of what exactly a PCP is, because they want it to be flexible and encompass all sorts of situations as times change as well. So ultimately, it is a question for the employment tribunal to decide whether it fits this description, but the general approach is that it will be construed really widely. So it will include, for example, policies, formal or informal, rules in the workplace, practices in the workplace, arrangements, criteria, conditions, prerequisites, perhaps for getting a job, qualifications, or certain provisions. It may also include decisions to do something in the future, so even a policy or criterion that has not yet been applied. It can also include a one-off discretionary decision. So essentially it includes not only a criterion that an employer imposes openly, but also a practice that's in fact applied without being written down or otherwise made official, when we talk about custom and practice. So essentially, as I say, it's quite wide, and it's some sort of action that the employer generally applies in certain situations, and that can potentially attract scrutiny under discrimination legislation. So once you've identified your PCP, you have to look at it as being the cause of the particular disadvantage. So it must be the PCP that puts the complainant at a disadvantage and not some other factor, which is, for instance, self-inflicted. So to illustrate, there was a case of the Ministry of Defence against Macmillan. A woman's employment moved to a new location. She decided not to move house and instead commuted every day, which was a round trip of 120 miles, 70 minutes each way. She was offered accommodation at the new location for her whole family by the employer, but chose not to accept it. I think because there was children in school, etc. And instead, after moving to the new location, she made a request to work part-time in order to accommodate childcare responsibilities. So the employer had a policy that all the people in the category of employees to which she fell must, for operational reasons, work full-time, and they turned down her request. So she obviously said that's not a fair policy to require all the individuals who work in this role to work full-time. So the EAT held that the problems the claimant had with childcare were self-inflicted by her decision to commute rather than to move house. And so in that instance, the detriment was not caused by the PCP. But you can see all the hurdles there that an employer has to jump over effectively, and the fact that potentially requiring a class of individuals to only ever be able to work full-time, which obviously does usually make it more difficult. It's commonly accepted that still women have childcare responsibilities, and tribunals will interpret the law as such. So you've got to watch these things when you're imposing a policy and that's kind of laid down carte blanche. So as I mentioned, the indirect discrimination has the potential to be justified and therefore defended. So essentially what you're showing there is it's a proportionate means of achieving a legitimate aim. And that includes disability, indirect discrimination, even some forms of direct age discrimination, and most commonly concern health and safety or occupational requirements in relation to a particular role. So examples of potentially discriminatory action that can be justified, certain contractual benefits that are linked to length of service, for instance, an extra day's holiday for every year, especially when that's up to 5 years. So potentially it's age discriminatory because tends to be perhaps older people who have longer serving length of service, but it can be justified if, for instance, it can promote loyalty or skill retention. I've had clients who've given, you know, statistical data about how difficult it is to recruit certain individuals with a particular skill, and therefore they want to give them a really kind of commercially attractive package, and therefore they can justify it. Or, for instance, having a female-only recruitment policy, so potentially discriminatory, obviously on grounds of sex, but it can be objectively justified in certain spaces, for instance, a female-only prison or other healthcare situations. So that's a quick run through of the key things to think about when you're thinking about indirect discrimination. And Gary,
yeah, Julie, sorry, just on that, you mentioned about health and safety ones. This is an area where it does come up quite a lot in terms of certain safety requirements that impact on other people, and we've had it quite a few times. I remember one quite memorable case for a client who had of all things, they had a no beards policy. So basically they couldn't, particular employees in this particular role doing this job were not allowed to have beards. In fact, they had to be completely clean shaven. And the reason for that was that they had to wear these really tight fitting face fit safety masks for the kind of gases and things that were in the environment that they were working in. And an employee complained to say that they felt it was discrimination. Now, after it only took a tiny bit of digging, but it clearly wasn't a discrimination case in that context, because it was just an individual who wanted to have a beard, wanted to be allowed to have a beard, and felt like his employer shouldn't be telling him he couldn't. But clearly in that context, that could be, in different situations involving different employees, it absolutely could be a discrimination situation, because if the reason why that employee wishes to have a beard is related to a religious or cultural or you know, that kind of reason, then even though that policy of no beards for every employee in that department applies the same to everyone, they're at a particular disadvantage because of their religion or their cultural background. In that context, the onus would have been on the employer to objectively justify why they have that policy. Now, when we looked at that, just as an exercise, we wanted to make sure that, you know, if that was ever challenged, which is possible, would we be able to justify it? And we felt that we would, because there was a clear, hugely important need for these face fit masks. And there weren't any reasonable alternatives, you know, a different kind of mask that would accommodate someone who had a beard. And they would potentially be able to move any individuals in that department to carry out slightly different duties. It didn't necessarily mean that employee would lose their job or anything like that. So there was different solutions to it, but in terms of that policy, which could be discriminatory, they were able to justify it. And it's just an interesting example of a real life example of where those policies that you think, well, that's completely fair enough, could be open to scrutiny if they, you know, affect particular groups of people. That's just one example that's always stuck with me, because it was a genuine situation that they faced.
I also remember a case about it was hard hats on a building site, and an individual said, well, I wear a turban, so I can't wear a hard hat. And obviously the health and safety justification was brought forth by the employer. But I think ultimately in that case, the tribunal determined that a turban would actually give similar levels of protection. I don't know if I would particularly want to rely on that, but and so they said the individual should be allowed to wear the turban instead of the hard hat. But you would obviously be getting lots of disclaimer forms there. So it just shows you that, again, even an initial you just presume that health and safety kind of trumps all. So even then, sometimes that can be challenged.
Yeah, that's an example, I guess, of the way these things are done to mean that it will be a unique solution in every set of facts. It's not necessarily going to be this is what always happens, and if you cite health and safety, then it trumps everything, and that's it. You're going to have to look, and you could easily imagine a scenario where, I guess, what the tribunal may have been saying is that in that context, you're not necessarily getting a particular advantage by wearing a hard hat, whereas there may be others where you absolutely would, and it's even more paramount that you're wearing it compared to not. And so it will just depend on the specifics of the situation, which is always the case, isn't it?
I think the key ultimately as an employer is to be prepared to have a degree of flexibility in relation to any blanket requirement, and to have a sensible, considered answer if it's challenged, and that can protect you in quite a few situations rather than a flat no.
Can I ask? You mentioned that. I'm just surprised that the suggestion that it could be discriminative to allow people to have additional days holiday for years of service. Is that a thing, or?
Yeah.
Yes, it's especially when it's beyond 5 years. So you any sort of kind of benefits or perks that go to long-serving employees have to be, there has to be a rationale there as to why specifically you're rewarding them in that way rather than in some other way, or why it's not being given to everyone.
It's more of an illustration, really, I'd say, Paul, in the sense that in theory it can fit within the indirect discrimination, because the idea being that you only get it after 5 years service. So if I'm fresh out of university at 22 years old, how can I have achieved 5 years service?
But then even if you're 50 years old and you've just joined the company, you can't achieve it unless you've done it doesn't matter how old you are, you have to work for the company long enough to get it.
But it's all about the likelihood of the...
I could see the reverse. If you were very near retirement age, and then you're very unlikely to have the opportunity to get that additional. And I just can't see how it would be the other way. A young person doesn't. What possible way could you relate that to age? You join the company like anyone, and you've got a length of time to get the rewards.
But it's you're more likely to. The idea is, or the theory is, you're more likely to achieve long service the older that you are, because you've had the chance to do it. And 5 years, okay, might not seem like that long, but that's usually the starting point of saying, well, scrutinize those kind of things on that level. You might have some employers who have, when you've been there 20 years, and then you're saying, well, the younger demographic of our employees just can't get there, and their suite of benefits is much lower than, or less favourable than the older group. It feels a little bit counterintuitive, but it is based. I'm not necessarily saying these cases are successful. It's not like stick this claim in and it's a winner. Clearly, this is the kind of thing which the courts have found a way of saying, well, no, that's sensible. That's what employers will do. We want you to stay with us. We'll unlock benefits the longer that you stay, and there's a justification for that. But the fact is, the older you are, the more likely you are to have achieved the long service. And the younger you are, the less likely you are. It seems a bit odd, but it is correct in that sense. It just doesn't mean that it's discrimination. It just means it could be discrimination. You can't justify why you do it.
So is there any, basically, if we wanted to implement this at my company, is it viable, or is it something we shouldn't touch with a barge pole? Like, should it be done with less than 5 years then?
No, it's definitely viable. It's about thinking why you're doing it if you were challenged. It's about possibly you might look to mitigate some of the impact of it by staggering it a bit more, so it's not quite as long as 5 years. You build up to the full benefits after 5, but you start working towards it, and that's what you see a lot of employers do. You know, after every year you get an extra day, for example.
Yeah.
And then at 5 years you've maxed out your extra 5 days. So actually it's a bit more proportionate, and it's a bit less open to challenge. But yeah, many employers have and would just have a blanket, you've got to get to 5 years, then you get this. And that can still be justified, but clearly it can be open to challenge as well if there's not a reason for it. Yeah, it's one of those that employers scratch their head about and say, well, how can that make sense? But in the wording of how the legislation works and how indirect discrimination, and that's clearly why you have this ability to objectively justify it, because otherwise there'd be so many differences in treatment.
It's a bit like saying, you know, all of our managers are more than 30 years old because they've got the experience. And people straight out of university don't have the opportunity to become a manager straight away. Well, that's because they don't have the experience. And therefore that seems to be ageist against university students because they're young.
Yeah. And that's where your objective justification would come in, wouldn't it? About what these people can do. But what you're challenging employers to do is go to that level to explain what experience means and what it looks like and what it adds, rather than just, you're too young to do that job, which is what people potentially would do in the past. We're looking, you put a job advert out, we're looking for people 30 or over. Well, actually, what you mean is,
do that.
Yeah, exactly. That's so blatant. But that's in effect what people used to potentially do. And when they say we just want people of a certain age because then they've got the experience. Well, actually, the age isn't the factor; it's the experience. They could be any age, but then coming back to the point we're debating, it's about, well, you can only get certain levels of experience with age. So it goes around in circles a little bit, and that's where your objective justification comes in, to give that common sense aspect to it. It doesn't necessarily feel like it, but it does allow that element of common sense to come into it, to justify those kind of things. So back to the holiday thing, as Julie said, it'd be about getting people to stay for a long time, stay with us as an employer. You get benefits the longer you serve, things like that. And that a tribunal will recognise that makes sense, and everyone would mostly recognise that makes sense. You get the people that will challenge it.
Cool. I mean, it's just relevant because we're looking at ways to improve staff retention, and that was something I was going to suggest. Just wanted to check that I'm not going to
and there's no reason not
massive problem.
Yeah, there's no reason not to, but the fact you're doing it off the back of a thought process where you're trying to look at ways to reward loyalty and encourage loyalty, then that's the start. That's you starting to build up the objective justification even before you've been challenged. This is why we've done these things, and this is how we've tried to introduce it so it has that impact without being too blunt. So you might stagger it, like we were saying. Then all that justification there is you starting to build up that defence if you ever needed it, and likelihood is you wouldn't.
Yeah. Okay.
So to be clear as well, it's particularly the thing that attracts the attention is after 5 years. So if you're doing service related benefits up to 5 years, you're pretty much okay.
Yeah.
So it's when it's more than that. That's when the objective justification requirement needs to kind of kick in. There are certain, as I say, accepted norms or accepted statistics. For instance, generally it's accepted that women tend to have childcare responsibilities, so that's an accepted norm that the tribunal will apply. And another one is that effectively the longer the length of service, the harder it is for a young person to comply with. But I've also had employers who go in with statistical data to show the age range of individuals in the particular category, and but it's just something, as you see, when you're rolling something new out, to have in the back of your mind, in that sense.
And it's a useful example of saying as well, I mentioned this earlier, that that's a direct discrimination. Yeah, they do happen. They happen sadly too often. But most employers are going, like we said there, well, I knew I wouldn't put a job advert out that said you must be a certain age. So most employers know enough to think, well, I'm not going to directly discriminate against someone. That's never been my intention. But they can then inadvertently apply procedures or requirements that indirectly discriminate against someone. In a lot of cases, like we're saying, that can be justified, but in others it can't, because it's not being thought about. It just is what it is. They don't really know why they've done it, but it does inadvertently discriminate against someone. So I certainly tend to see more cases based around indirect, and then, as we said earlier, harassment, but that's a kind of different kind of scenario. see that more than I see someone saying, I didn't get this job or this promotion for the specific reason that I have this characteristic. Can still happen, as I say, sadly happens too often, but it's those inadvertent scenarios that most of us will be trying to avoid because we know enough to avoid the direct scenarios. So just moving on to a couple of final points that we wanted to make is around liability for employees' actions. A lot of employers don't necessarily like this for understandable reasons, but as an employer, you will be liable for any discrimination committed by anyone that you employ, provided that discrimination is done in the course of that person's employment. A fancy name for it is vicarious liability. But in effect, one of your employees discriminates against another, you can be held liable, and you often see tribunal cases brought against the actual employer as a company, not because of something they did, but because of something their employee did. Typically, you're more likely to see that. Yes, you might see it in management decisions and things like that, but typically as well, you're likely to see it in harassment cases where employees have once said something about the other or done something towards the other, name calling, the dreaded phrase around banter, that kind of thing. That's often where you will see these vicarious liability claims being brought. Now, it is possible to avoid that liability or to defend that claim if you're brought into it and blamed for the conduct of another employee. If you can show that you took all reasonable steps to prevent the employee from doing what they did, so from committing the act of discrimination or anything like that. Now, it's examples of how you might do that are having really robust equality policies and procedures, dealing with any issues that come to light quickly and consistently, regularly training staff on diversity and equality issues, and things like that. Now, it is a relatively high bar, and the tribunal typically are not going to let an employer off the hook simply because they say, oh, well, I trained my staff on equality and diversity a couple of years back, so that covers me against all vicarious liability. This is not going to wash. But if you're genuinely committed to equality and diversity, you regularly train your employees, you make it very, very clear what's accepted, what isn't, then in theory it's possible to defeat a claim where you're brought in on a vicarious liability basis by demonstrating that you took all reasonable steps. And it's that phrase, all reasonable steps, which tells you why it's so hard, because you can point out 5 reasonable steps that you took, and the employee can name 5 others that you didn't, and make the argument you didn't take all steps. And it just becomes a difficult one to be arguing, but it is there, and just shows you the importance of having these cultures and procedures in place.
Yeah, there's always got an example.
Oh yeah.
It's live and we're dealing with it at the moment. So we've
got. Are you mentioning this to if it's on record, or do you need us to stop? Or?
No, it's fine, because I'm not going to make names.
Yeah.
So we've got one particular person who's a junior employee in store who's got a club foot. And his newly appointed store manager thinks it's okay to mimic him, the way he walks. Okay. So we've spoken to, he's actually got somebody that's witnessed this. So, and he's even, this newly appointed manager has actually said in front of a police officer, because he was talking about what he could do during the Jubilee celebrations. And she's actually said, you can't be going out partying with your disability.
Well, okay. Yeah. So yeah, that's.
So it's only happened a couple of times,
yeah.
But the junior member of the store obviously feels quite aggrieved by this, and we've got to just nip it in the bud.
Yeah.
Yeah.
So the key in those kind of scenarios will be, okay, well, as what we've said there, you could be vicariously liable for those comments. So if the employee on the receiving end of that now wanted to bring a claim about it, they could do, and it may be quite difficult for you to use that defence we've just mentioned. So just because it is, not because of anything you've done, just because it is. Now, clearly, therefore, on a practical basis, and this is what we get involved with clients with a lot, it's really important how you react and deal with that. And some employers might be reluctant to get too embroiled because they think it makes it into a bigger deal, and actually if they make certain admissions it might result in claims and things like that. But actually, in my experience, if you go in there and deal with that properly, you're going to avoid that becoming a claim, because a lot of the time the employee complains about it. They're not looking to bring a claim and get compensation. They just want it to stop. They might want an apology, and they might want to make sure that you're going to improve certain aspects of equality and diversity, things like that.
Yeah.
But if you can go in and deal with it, that's often a much better scenario than trying to rely on the limited defences that you have. And I know you guys would be good at doing that kind of thing. I know that you're hot on getting involved and dealing with those scenarios, but obviously many employers would kind of just hope it goes away, not want to accept it.
The general rule of thumb as well is that the bigger the organisation, the more is required for them to tackle these things and to have really obvious programs that they can point to. Obviously, if it's a really small organisation, they don't have the same sort of resources. The bar is definitely lower. But all employers and all businesses are required to address it in some fashion.
Yeah, and some. Clearly as well, some employees need to be reactionary to kind of reactive to what happens. So they might start seeing, well, actually, we thought we had this covered, but you know what, we're seeing more. I had certain clients that suddenly had a run of sexual harassment type cases, comments, not obviously anything like that serious, but it was more around comments and just intimidating comments and environments. And they were just seeing more and more of it. And their generalised equality and diversity training, they realise that's probably not enough. We need to put everyone through a bit of a course that says, particularly if you've got young, and I shouldn't, maybe in the context of what we're saying, maybe this is not the right thing to say, but particularly if you've got people new in the workforce, they don't necessarily, they've not seen this before, and they don't know what's acceptable and what isn't. And it can be really important to say, no, I'm going to zone in on that particular issue because it keeps coming up. And if that ends up in a claim, I want to be able to say that, yes, we did general training about this, but when we spotted issues, we zoned in on particular things to make it very, very clear what was not acceptable. And then it happened the very next day. Well, what more could we have done? We literally told this person not to do it, and they went ahead and did it. There's things like that you can then hopefully gives you a better chance of arguing that you've got the right to rely on that defence.
The employee he just wants it to stop.
Yeah.
The newly appointed store manager is actually transferring to another store, and what he's actually said is, I don't want anybody else to have to suffer what she's done.
Yeah.
So I just want to get it all nipped in the bud, by the end of the week, so that he knows that we've done something, but she also knows that, you can't do that.
No.
So do we use that as discrimination? It is discrimination, isn't it?
It is, yeah. I mean, obviously, it's not acceptable anyway, is it, regardless? But the reason why it's discrimination here is because, as she alluded to herself, his clubfoot condition could be a disability. I don't know. I mean, it might not be in theory, but equally it might be. Any medical condition can be a disability. So the point is, if it is, then yes, it falls squarely in the discrimination legislation. Even if it wasn't, it's still not. It wouldn't technically be harassment and discrimination, under the legislation. But it's still something that an employee could complain about. It's still something an employee could say constructive dismissal, for example, and doesn't reflect well, if it's not dealt with properly. So chances are it is discrimination, even if it's not. As the employer, as we know, we want to avoid that, because the next thing they tease someone about could be their race or their age or something. You know what I mean? If that's what they do, so you just need to nip that in the bud, like you say.
Okay, lovely, thank you.
No problem. And then I think there's just one final thing that Julie was going to mention around potential consequences, and then how to protect ourselves, just in general terms, how to protect ourselves from discrimination claims.
Yeah, so ultimately discrimination is a claim that can be made from day one of a person's employment. You don't need any sort of length of service qualification. In fact, you can even mount a claim of discrimination if there's a discriminatory recruitment process. So it's something you've got to be live to right from the start. Lawyers always like to scare clients by saying that compensation for discrimination is unlimited, but in reality, the sorts of figures that we're talking about, there's guidance that came out in a particular case, and it's always updated in relation to cost of living. So there are kind of three main bands for compensation for injury to feelings. For an individual who suffered discrimination, and that would obviously be in addition to potential financial compensation, which is calculated more in the same way as unfair dismissal awards. But the injury to feeling compensation is three bands. The first band is up to about £6,000, and the middle band is between about 6 and 15, and the top band for really serious cases of discrimination, where it's like a campaign and just dogs the person's life effectively, is from 15 to 40. And you can also have kind of an aggravated award as well, which can take it beyond that. But as I say, the individual's obviously compensated for two aspects: financial loss and injury to feelings, and there is no cap on it, unlike unfair dismissal, which is capped at a year's salary up to, I think it's about £98,000. So it can be a very costly mistake effectively, and the ways that no problem, Paul, bye. The ways that we suggest that you guard against it, as we've mentioned: policies, training, especially managers, because they're the foot soldiers. They're dealing with it, day to day, so they need to know not only how to respond, but what could potentially be a problem. For instance, Sue's example: oh, that person's got a club foot, they're making fun of it, that is ringing alarm bells. It's obviously a bit worrying that it's the manager themselves that is doing it, but so those are the kind of areas that you want to focus on: training and policies. And the final point I would make, so I know we're up against it for time, is post-pandemic. There are a lot of new employees that are being brought on, so they will not maybe have had the training that you've previously rolled out. So consider it being part of your induction, that it's mentioned, it's part of the staff handbook, etc. And also refresher courses for existing staff, because not many employers were worrying about diversity training during the pandemic. So now that we're getting back to more normal life, it's definitely something that should be being ticked off the list.
You mentioned there about how important training is. Do you know anyone that does training on those kind of issues, or anyone you can recommend that might?
Well, there's a great dynamic duo, Julie and Gareth, happily come and give diversity training to any of you, if you wanted to.
Yeah, but no, in all seriousness, we can help with things like that in terms of we do train management groups and things like that on not necessarily making them to absolute experts on things, but as Julie says, how to spot issues, how to know when to flag it up, how to know when to seek advice from ourselves in more detail, or HR, depending on what your structure is. So that can really help, and if that is something that you think might be able to help with, then obviously give us a shout.
Yeah, great. And I think that's us, almost bang on 10:30, in fact overrun a little bit.
Yeah,
everyone happy with that? Any questions? No, good. Well, we'll let you go and enjoy the rest of your day. Thanks everyone for coming.
Thank you.
Thank you. It was really insightful. Thanks so much.
Oh, good.
Many thanks.
Thanks everyone.
Bye.
Bye.
Bye everyone. Thank you.
Bye.
Cheers. Bye.